Hello, welcome to Bite-Size Law. I'm Amanda and I'm a private tutor in property law. In this series of videos, I'm going to be looking at the system of unregistered title, or unregistered land as it's also called. So first of all, I want to briefly look at how this topic will fit into your study of land law generally. As I explained in my first series of videos, Introduction to Land Law, a key part of studying land is about how you deal with property rights which are owned by different people in the same plot of land. You'll be studying the rules to work out whose right takes priority. The most common situation where competing property rights occur is when title or ownership to the land changes, but there's a third party, so someone other than the current owner, who has an existing right over the land. So as you will very soon discover, the owner of some property rights, particularly equitable rights, may lose their right if they fail to do something to protect it. Now, if you're just starting to study law and you don't know what the individual property rights that we're going to look at are, you may find this topic difficult to grasp at first. But don't panic, you will learn about these rights as your studies progress. So just to show you what I mean by property rights and third parties, let's take a very straightforward example. Sarah is a landowner, so she owns the freehold estate, and she grants a right-of-way over her land to her neighbour, Mrs. East. And a right-of-way is an interest in land known as an easement. And later, Polly becomes the new owner of the land. So whose right in the land takes priority? Is it Mrs. East's right-of-way or is it Polly? Well, what we'll see is that just because Mrs. East's right was granted first, that doesn't necessarily mean that it will automatically take priority over Polly's right to enjoy the land as the new owner. Now, before we move on to look at the rules relating to unregistered title, I just want to deal with a potential source of confusion. So I want to look at what we actually mean by registration in land law. And the reason why there is potential for confusion is that there are two completely different systems, which are unregistered and registered title. But both systems involve a form of registration. Now, in 1925, a new system of registering title or registering ownership to land was introduced, and all interests affecting the land would, in theory, also be on this central register of title. The reason for creating a system of central registration of land was to help purchasers of land to find out about interests affecting the land that they were thinking of buying, and also to allow people who were the third parties who had the benefit of a right in land that they didn't own, the opportunity to protect their right so that it could be enforced against later owners of the land. But obviously you can't just register all land ownership overnight, and so also in 1925 another system was introduced alongside the new registration of title system, which was the land charges system. And land charges were intended to be a temporary stopgap until all the titles to land had moved over to the new registered title system. But it has taken a long time to register titles, and there are still large areas of land where titles haven't been registered. So there are two current systems. One where title has been registered, and the other system where title hasn't yet been registered, which is referred to as unregistered land. But just to stress, within this system there is an element of registration, which is registering land charges. Now, as you would expect, some of this 1925 legislation has been amended and replaced along the way in new legislation, but you may find it helpful to keep in mind those two different systems and why they were introduced to help you understand the law in this area. So this series of videos is about unregistered land, where title to the land hasn't yet been registered. And what you'll see is that within this system, there are three different elements. Land charges, the temporary system that I was just referring to, the common law system of the doctrine of notice, and also something which is called overreaching. So in terms of this series of videos, I'm going to break the law on unregistered title down into bite-sized pieces, and I'm going to be doing separate videos for each of those three elements. And in my final video, I'm going to show you how it all fits together, so that when you're faced with a question on unregistered title in an assessment, you know which of those three elements you need to be dealing with in any given situation. So now let's start to look at the rules, and what you will discover is that the legal equitable distinction is extremely important in unregistered title, and it's always going to be the first thing that you work out after you've worked out what broad type of property right you're dealing with. I've done a series of separate videos on how you work out whether a property right is either legal or equitable. So if you're unsure about how to work it out, check out those videos. So the system of unregistered land starts with a really easy rule, which is that if a property right is legal, then it takes priority over any later rights in the land. So the rule is that legal rights bind the whole world. So a pre-existing legal right in land takes priority over new owners' rights in the land, whether the new owner knew about that pre-existing right or not. So if we go back to the Sarah and Polly example, if the right-of-way is a legal easement, it will take priority and it will bind the purchaser, Polly, whether she knew about Mrs. E's right-of-way or not. But now it gets more complicated when we look at equitable property rights, because this is where the three separate elements or three separate sets of rules come in. They are the system of land charges, doctrine of notice, and overreaching. If we go back to our example, if it's an equitable easement, we have to work out which set of rules or which of those three elements applies to this type of equitable right, which is an easement. If you remember, land charges were intended to be a stopgap until all title to land within England and Wales had become registered. So the system of land charges replaces the common law doctrine of notice for certain property rights. But here's the key point, it doesn't cover all equitable rights. So it's very important to appreciate that the system of land charges that we're going to look at now and the old common law rule of the doctrine of notice are mutually exclusive. So you don't switch from one system to another when you're dealing with the same property right. So if a particular type of property right can be registered as a land charge, then you deal with it within the land charges system. So you either follow the left-hand pink route or you follow the right-hand side, the doctrine of notice. So what you need to do when faced with a pre-existing equitable proprietary right is to decide whether it can be registered as a land charge, because that will tell you which set of rules you need to apply, so which route to follow. If the particular right can be registered as a land charge, then you need to look to see whether it actually has been registered. And the way it works is this. If this particular right can be registered as a land charge, but it hasn't been registered, then it isn't binding. So it doesn't take priority over future purchasers of the land. And that's the end of the story. And I want to stress that you don't then go on to look at the doctrine of notice for this particular property right. So what's the position if it has been registered as a land charge? Well, then it does take priority over future owners of the land, including purchasers. So you can see how the system of registering a land charge protects third parties who have an interest in the land. Now let's quickly look at the mechanics of the land charges system, and the relevant rule is set out in section 3 of the Land Charges Act 1972. And what you'll see is if the property right can be registered, then it's registered against the name of the owner of the land which is affected by the right. And the easiest way to see how this works is by looking at our example with Sarah and Mrs. East. The land affected is Sarah's land, so Mrs. East will register a land charge in the name of Sarah against Sarah's land. And in that way, Mrs. East will protect her right of way over future purchasers. Now, there are all sorts of problems that can arise under this system, such as registration in a similar but incorrect name, which you may or may not cover as part of your particular law course. I'm not going to spend time going through the cases here because many courses are now reducing the amount of time that they spend looking at unregistered title generally. So check your course syllabus to see whether you need to go into more detail here. So that ends our brief overview how the system of land charges works, and what I'll be dealing in my next video on land charges is looking at which particular rights can be registered, and I will be going through some worked examples with you as well.